Hey guys, and welcome back to my channel. This is Debbie. We are back for another episode of Paralegal Reacts, and we are reacting still to the Johnny Depp versus NGN, specifically to NGN's closing arguments. So if you hear any background noise, I do apologize. There's some construction going on. At least I feel I finally figured out how to get the audio to come out of both sides. And I've turned the fan off, so we got to work with what we got here. But yeah, hopefully it's not too bad. But yes, let's get into it because we got a lot to go through. The first point that I've kind of put down here is where in their arguments, NGN had said, the main charge of the libel is wife beating. A single incident of violence on the part of the claimant towards Ms. Heard will suffice for the purpose of proving truth. The defendants have, however, in this trial proved that the claimant was violent towards Ms. Heard on several occasions. And to that I would respond that this libel case is centered around the term wife beater, which is defined by the dictionary as follows. Wife beater, a man who regularly or habitually hits his wife or female partner. So while in my opinion, the defense failed to prove without a doubt that Johnny Depp abused Amber Heard, the allegation was that Johnny Depp habitually beat Amber, as per the definition of the term wife beater. They have failed conclusively to prove that Johnny Depp was abusive towards Amber definitively, whether that was a singular time or habitually. The next point that they have here speaks to the claimant's reliability. So defense had said that the claimant was not a reliable witness. He conceded that he had never read his whole witness statement. When challenged about the headbutting on the 15th December 2015 and asked why his new account that he had headbutted Ms. Heard, albeit accidentally, was missing from the statement, the claimant confirmed that he had not read the entirety of his witness statement before signing it. He said, had I read the entire statement after the lawyers had drafted it, I would have found that missing piece. I did not read all of these things. It was just altogether too much information, and I trusted that my attorneys had taken my statement and put it on the record. And to that, I would respond that the defense claims that Johnny was not reliable, but their star witness, as it were, Amber, was consistently changing her story. One day while on the stand, she stated that she was not there when Johnny had his fingers severed. The next day she said she saw it. But Johnny has remained consistent. Of course, they will try every trick in the book to try to win this, but that simply is not true, especially when you compare his testimony to Amber's. In my opinion, Johnny is a much more credible witness. When Amber Heard was confronted with things that were added or missing from her original statements, she would say, it's impossible to include every detail. So why can't defense counsel keep the same energy when it comes to Johnny? Then defense counsel said, there is no dispute that the claimant was, during the relationship with Ms. Heard, a very heavy user of controlled and prescription drugs, as well as being a heavy drinker, save during certain limited periods of sobriety. The question for the court is whether his use of drugs or alcohol prompted him to become abusive and violent on occasions, and whether it affected his ability to recall events that had taken place when under the influence of drugs or alcohol. To that, I would respond that just because someone partakes, in drugs and alcohol does not mean they are abusive. The fact that the defense counsel states, the question for the court is whether his use of drugs or alcohol prompted him to become abusive and violent. At this point, we should not still be asking questions. The onus is on the defense to prove that Johnny was abusive and violent. Had the defense done their job properly, they wouldn't be putting questions to the court in their closing submissions. At this point, all they can do is try to create doubt, as this case is based on the balance of probabilities, meaning the judge has to be 51% of either side's case. Then defense counsel goes on to say, an example of the effect of such substance abuse on the claimant was provided by a photo of him from 18th July 2013, which showed the claimant passed out, curled up in a ball, seemingly after drinking or taking drugs to excess. To which I would respond, It has come out in this case that Amber also drinks and takes drugs to excess. So by their logic, how can they not be sure that she became abusive and forgot her abuse during her substance abuse? Using drugs does not mean you are abusive, and it's a faulty argument considering Amber Heard also drinks and does drugs. A picture of him passed out in a bad moment doesn't prove anything besides the fact that Amber had a desire to embarrass and dehumanize him. Then defense counsel would go on to say, the relationship between the claimant and Miss Heard was complex and became toxic. Comparisons cannot usefully be drawn with the relationship the claimant had with other partners. Miss Paradis and Miss Ryder did not attend to give evidence, so the defendants were deprived of an opportunity to explore with them the claimant's conduct towards them. But in any event, the claimant confirmed that his relationship with Miss Paradis was not characterized by the same level of drug and alcohol abuse as a relationship with Miss Heard, save towards the end when the claimant accepted he drank to excess. And so to that, I would respond that the fact that the defense brings up the fact that Miss Paradis and Miss Ryder did not attend to provide evidence as a deprivation is ridiculous. As you may recall, the defense was given the option to examine both of the parties, and they stated that they did not see a need for it as they felt it was not relevant. If they wanted to examine them both witnesses were ready for questioning via video link, but the defense declined. Then defense counsel goes on to say, Mr. Duder's observation was apt. I think they were two people that were in love with each other that, should not have been together. To which I would then respond, I'm not sure why this was included as one of their arguments, as I'm unsure how this statement proves anything to do with their case or displays that Johnny was abusive. I believe that all Mr. Duders was saying was that they were not good together. Some people simply bring out the worst in each other, or if one of the parties are abusive, that party being Amber in my opinion, that certainly means that the parties should not be together. Defense then goes on to say, there was a contest as to who was in control of the relationship. Miss Heard explained that there were many ways in which he sought to control her. She gave an example of the claimant arranging for her to be driven around while her car was renovated. And the court also heard evidence that the claimant sought to intervene in her career in unhelpful ways. Miss Sexton explained how she heard the claimant talking about Miss Heard's career and was disparaging her choices. Which to then I would respond that I believe that critics the world over have disparaged Amber Heard's choices in movie roles, as well as her acting abilities. I would strongly question the competency of Miss Sexton as an acting coach, given Miss Heard's horrific acting abilities, as evidenced in her body of work within film and television, and her testimony in this case. Depp is clearly an expert at the field of acting, judging by the longevity of his career, as well as his excellent ability to realistically portray a wide variety of characters. Miss Heard should have taken his advice. Her career might have been able to be successful without having to resort to PR moves and hoaxes to further it. The next point we will discuss from defense is when they said, moreover, despite having claimed in his witness statement that Miss Heard did not support his sobriety and often encouraged him to take drugs and drink alcohol, the claimant accepted in cross-examination that Miss Heard was adamant during their relationship that he should stop drinking and using recreational drugs. To that, I would again reply that Amber Heard was so adamant that Johnny refrained from drinking and doing drugs that she would use in front of him while he was in a period of sobriety. If she was truly a supportive partner, she would not continue to drink and do drugs in his presence while he was trying to remain sober. In my opinion, it could very well be Amber who led to his increased use, as he had not been using to such a degree prior to their relationship, and from what I can tell, he seems to be much better off since the relationship breakdown with regards to use of drugs and alcohol. Then defense would go on to say, much time was spent exploring the topic of the importation of the dogs Pistol and Boo into Australia in 2015. It was not a fruitful or worthwhile exercise, not least because Miss Heard pleaded guilty to an offence of producing a document knowing it to be false or misleading. And the magistrate in Australia found that Miss Heard had not deliberately set out to deceive the Australian authorities, and that this case was not a case of a person believing she is above the law. So, to that I would reply, I question why defense brought this up to Amber's credit, as one of Johnny's witnesses, Kevin Murphy, testified to only writing a statement in Amber's defense under duress, and that he withdrew his statement. It was noted that had Kevin Murphy not made his statement in support of Amber, she would have been in a lot more trouble, and her charges would have been much more severe. After this came out, the Australian government has publicly stated they are considering whether to pursue perjury charges against Amber Heard. And I found this article here, so let me just read it out for you guys. It says, breaking hound news. The Australian government is considering whether to charge Amber Heard with perjury over the pistol and boot palaver after Johnny Depp's former employee claimed he was forced to lie under oath about the dog's illegal entry into Queensland. It says the Department of Agriculture, Water and the Environment is aware of recent media reports concerning the prosecution of Miss Amber Heard in Australia in 2016 and is consulting with the CDPP on this issue, a spokesperson told Struth. After a bit of sniffing around, senior sources informed us an investigation was potentially on the cards. The maximum penalty for perjury in Queensland? 14 years in jail. So the next point I want to discuss from their closing argument was one they said as follows. Miss McMillan stayed with Miss Heard in London, and then Miss Heard invited her to come and stay with her in LA to hang out and see what it was like. Miss Heard already had a full-time assistant, Kate James, so did not need Miss McMillan as an assistant. She was just helping out with grocery shopping and similar tasks occasionally, as did other friends of Miss Heard, which is what the payments were for. Other friends also used the assistant email address at times. When Nurse Borum noted that Miss McMillan was Miss Heard's assistant, this was because Nurse Borum had known Miss Heard for 2 years already, and Miss McMillan had indeed been her assistant outside of the United States at times during that period. The money which Miss Heard paid Miss McMillan was for expenses and a loan. Okay, so I'm going to reply as follows as well. The fact that Miss Heard lied about hiring her friend Miss McMillan to work for her illegally as her assistant strongly shows she believes she's above the law. If Samantha was responding to emails via her assistant email, she was for all intents and purposes acting as her assistant. That, combined with the fact that Amber cut her a check for $1,600, makes it very probable that she was working illegally for her as an assistant. $1,600 is a large sum, much too large to be explained away as being for expenses and a loan. If Miss McMillan truly was not working and was just there to experience LA, how would Miss McMillan have paid back this loan? Next, defense had said, the court does not need to resolve whether Miss Heard had such relationships with Mr. Musk or with Mr. Franco, since it is irrelevant to the question of whether the claimant is a wife-beater, save to the limited extent that the claimant's evident obsession with Mr. Musk and Mr. Franco is consistent with Miss Heard's account of the claimant's jealousy with regard to these individuals and the problems this caused in the relationship between her and the claimant. And to that, I would respond, the defense forgets that there is proof of both Mr. Musk and Mr. Franco going up to Depp's penthouses with Amber at all hours of the night and staying for the duration of the night. This is evidenced by both witness testimony and CCTV footage. This was brought up by Depp's counsel to show the type of person Miss Heard is and her lack of morals, not to mention the fact that it shows whatever concerns Depp had about Franco and Musk were warranted. Next, defense stated, this evidence was gratuitous and plainly adduced by the claimant in an improper attempt to publicly smear Mr. Musk, reflecting his determination to seek vengeance against Mr. Musk, another of the claimant's objectives, as he explained that he had in his text to Mr. Carino in August of 2016. To which I would then respond. The fact that NGN states that any of this is an improper attempt to publicly smear Mr. Musk is very telling. Mr. Musk is not a party to this action, nor was he a witness. The fact they care at all about what the public thinks of him is crazy. The Sun has ties to Tesla, and a conspiracy theory says that's exactly why they printed such a defamatory article about Depp and doubled down to the very end, refusing to retract until this very day. It is in fact alleged that Mr. Musk and his associates that have defamed Depp and created the cause of this action. Then defense counsel goes on to say, Ms. Heard was cross-examined at length about the contents of conversations she had with the claimant, which the couple recorded. The court can derive only limited assistance from these conversations. The recordings were created as part of an attempt by the couple to improve, or at least understand, their relationship. They were not ever meant to be a full and frank discussion about the relative culpability of Ms. Heard and the claimant in relation to acts of alleged violence or other confrontations. That would have rendered the conversations futile. Ms. Heard said the objective, as far as she was concerned of the conversations, was to actually talk about the real issues in the relationship, the structural issues. So to that, I would then respond that this is nothing more than an attempt to explain away evidence wherein Amber Heard admits to abusing Depp, and you can really tell the dynamic of the relationship. It was through these audio clips we were able to understand how Amber truly communicates, and we were able to understand that she is not the victim she purports to be. Then defense counsel says, as Ms. Heard explained when asked about why she did not accuse the claimant of violence at certain moments in one of these conversations. It quotes her, I knew better than to fight with him about the details of the fight and what he perceived as insult, injuries, or grievances that fallen on him. My job was just to try to say sorry and let us move on to the bigger point. Let us keep him on track and talk about other things. I had to, or else I would not have been able to finish the conversation with Johnny. I would have made him more mad, more enraged, and he would have gotten even more violent with me. To that I would respond, this statement is nothing more than Amber trying to explain away evidence yet again. However, we all heard the audio and it speaks for itself. Anyone who has ever been a victim of abuse would recognize the language and tone that Amber had used. Amber admitted that Johnny would always run away from their fights, and that angered her. Throughout the audio, she attempted to gaslight Johnny, telling him that she never hit him as she tried to convince him the abuse was all in his head. Now, Amber is attempting to gaslight the world as well. We all heard the audio. The gaslighting will no longer work. Then defense would go on to say, in cross-examination of Ms. Heard, reliance was placed on notes made by third parties who are not witnesses regarding what either Ms. Heard or others had said, particularly Nurse Erin Borum and Dr. Kipper. Ms. Heard explained that in some instances what they had recorded in those notes was incorrect and did not accurately reflect what she, Ms. Heard, had told those third parties, or in some cases did not reflect what Ms. Heard had told others, who in turn told the third parties who made the notes. Example, Nurse Borum's notes concerning Ms. Heard's medical history were made on the basis of what Dr. Kipper had told her. The court should be slow to reach factual conclusions based on hearsay evidence contained in those notes, particularly where, as here, the contents are in part double hearsay. The claimant could have called Dr. Kipper and Nurse Borum to give first-hand evidence of what they had witnessed and been told, but chose not to. To that, I would then respond. The fact that Amber tried to explain away what medical professionals wrote in their notes is laughable. Anyone who has ever gone to a doctor's appointment would know that doctors ask a lot of questions, they ask you to repeat things, and they double check everything because there's no room for error in the medical field. They would never, under any circumstances, include hearsay in your medical records, much less double hearsay. They would only input information obtained by meeting with you in person. Certainly not anyone on your behalf discussing you while you were not present. In my opinion, the reason why they did not testify was due to doctor-patient confidentiality and due to the fact that they were providing care for both Johnny and Amber, and this would create a conflict of interest. Next, the defense counsel said this. They said, Miss Heard texted her mother on 22nd of March 2013, stating of the claimant, "He's nuts, Mom, violent and crazy. I am heartbroken that this is who I love." The following day, Miss Heard texted her mother, enclosing a photo of the bruise to her arm sustained 2 weeks earlier as a result of the altercation with the claimant. To that, I would then respond, it is interesting that defense counsel refers to the text message exchange between Amber and her mother, because it was in that exchange that Amber specifically stated that Johnny was not physically abusing her. She tried to explain that away as her not wanting her father to find out and hurt Johnny. However, in the divorce case, during her deposition, Amber stated that she told her mother very early on about the abuse. So, yet again, her story changed. Then, defense counsel says, on 11th of June 2013, Miss Heard set out in an email she sent herself her concerns about the claimant's Jekyll and Hyde character, his drugs and alcohol use, or having to deal with the monster, the full-on disco bloodbath, and what she had come to expect, and the fact he surrounds himself with people who enable him to act in these ways and don't call out his bullshit. Miss Heard said, "You have hit me repeated, something you should have never have done. What a fucking man you are. And none of this would have been possible without the booze and drugs. None." So to that, I would respond, an unsent email to yourself hardly constitutes evidence. She could have written, or you can write whatever you want because it's an email, like no one is ever going to see it. So why was it never sent? I find that incredibly suspicious. This unsent email to herself proves nothing. Next, defense counsel says, shortly after the Boston plane incident on 24th May 2014, Miss Heard texted Kate James saying, "I have to leave JD. He's just freaked out on me. He's drinking again. It's bad. Worse than ever. I need out." The following day, Miss Heard texted the claimant's sister saying, "Yes, and I do hope he gets better this time, but I can't keep staying and supporting him just to watch him do it all over again. He has done this many times before. Tokyo, the island, London. Remember that? Many, many times, and I always stay. Always believe he's going to get better, and every 3 or so months, I'm in exactly the same position." And then, to that, I would respond, despite what Amber wants the world to think, it was in fact Johnny who wanted a divorce, and Amber filed first, and provided Johnny with the list of demands and gave him the weekend to respond. He was out of town filming a movie, and so she made an ex parte application for a restraining order and alerted the media. Amber wanted to destroy Johnny just like a true abuser would, with the mentality, if I can't have you, nobody can. Then defense counsel says, it remains uncertain what the claimant contends motivated Miss Heard to carry out this highly sophisticated 3-year dossier hoax. Insofar as the claimant's thesis is that she was a gold digger who had long planned the hoax in order to extract money from him. Miss Heard confirmed that she did not benefit financially from making allegations of domestic violence. She also saw no benefit to her career. To which I would then reply, Amber Heard won an award of $7 million, which she alleges she donated to charity, but has never provided proof of this. Even if she donated the money, she would receive a tax write-off of $7 million, which would be offset against any income she made as an actress. Prior to Amber divorcing Johnny, nobody knew who she was, and she was only getting very small parts. After the divorce and the allegations against Johnny, she received a lucrative deal with L'Oreal as an ambassador, as well as a major role in the Justice League and Aquaman movies. After the allegations, she became a star in her own right and a household name and activist. To me, it wasn't so much about financial gain as it was to boost her career. Next, the defense said, for example, if, as the claimant suggested, calling 911 on 21st May 2016 was a choreographed hoax for sure, why did Miss Heard not tell either of the two sets of police officers who then attended that she had been attacked? To that, I would respond, Amber did not tell the police she was attacked because she had no visible injuries and there was no damage to the penthouse. She only needed there to be a record of her calling the police in order to obtain her temporary restraining order. The police reports speak for themselves. A police officer would have no reason to lie and an ethical obligation to tell the truth. There's no way that her testimony and the testimony of her friends outweighs that of officers of the court. It is for that reason that defense counsel refused to examine the second police officer because they knew that it was damning for their case. Next, defense counsel says, why refrain from making any allegation that the claimant had been violent when emailing Mr. Tillett Wright, a close friend and confidant, on 11th February 2016? Then it goes to say, Mr. Tillett Wright, what the holy fuck happened this time? Heard. He just lost it, literally switching personalities like channels on a TV. It was nuts. Right. Did he hit you? I thought you guys weren't seeing each other. Heard. No, he didn't touch me. To that, I would respond, Miss Heard did not tell I.O. that Johnny was violent because, in my opinion, he wasn't. Defense counsel is trying to muddy the waters, but they are asking us to believe that Amber was being abused both when she says she was and when she clearly says she isn't. Which is it? Next, defense says, it was repeatedly put to Miss Heard in cross-examination that she was making it up as you go along. The basis for this was an accusation that Miss Heard was changing or developing her account. It is unclear how this is intended to fit with the claimant's apparent case that Miss Heard meticulously pre-planned the hoax over a number of years. To that, I would respond as follows. What Depp's team meant was that Amber was constantly changing her story and adding new details and allegations to embellish her claims. That is exactly what was meant by making it up as you go along, and what is going to work against her as her story became increasingly outrageous to the point where I don't think it's believable whatsoever. Each time Amber would retell her allegations, she would change her story or add new details that she didn't have time to talk about before, despite having made 7 witness statements over the course of many years. Next, defense counsel says, Miss James was extremely ill-disposed towards Miss Heard, as demonstrated by her testimony in general. She had been sacked by Miss Heard. She was happy to help the claimant to attack Miss Heard, as demonstrated by a text she received from the claimant on 13th August 2016, stating, "Thank you, sweetheart. I'm disgusted that I ever fucking touched that scum. Back on Tuesday and then court. We'll hit you when I get back, doll. Come over for a spot of purple and we will fix her flabby arse nice and good. Loveth, J." To that I would respond that Miss James did not like Amber due to the horrific treatment she was subjected to by her, nothing more, nothing less. She was willing to testify about her horrific behavior in order to do the right thing. Her behavior towards Miss James speaks to the kind of person she is, that she would treat an assistant so horribly and abusively. Next, defense says, Miss Heard's account is in her first statement at paragraphs 44 to 51. The claimant hit Miss Heard twice after she laughed at his wino tattoo. In oral evidence, Miss Heard confirmed the nature of the attack, the redness caused to her face as a result, and said it had been the first time I had been hit like that since I was a child. Miss Heard denied the suggestion that she was just making it up as you go along, and explained that she had said this from the very beginning. I had told my therapist about it years ago, actually the day after this happened. The claimant's position was that he does not recall any conversation or any argument about one of his tattoos, and simultaneously that the incident did not happen. So, to that, I would reply. Amber says that she told her therapist about this incident but fails to provide any proof. If she indeed had discussed this with her therapist, they would have made the appropriate notes, and she could provide proof by obtaining copies of her records from her therapist. She provides no medical proof whatsoever at any point for any of her allegations. She relies solely on her friends' testimonies and her own testimony, but was unable to provide proof of her seeking treatment for any injuries she alleges Depp inflicted upon her. Next, this defense counsel says, Ms. Heard got the date of the incident wrong in her first statement for these proceedings. The incident, which was referred to in a text on 12th of March 2013 as a disco bloodbath, took place earlier that month on 8th March 2013. It was during that earlier incident at the Eastern Columbia building that the claimant had hit Miss Heard with a backhand using a hand with rings on near a fridge in a way which caused blood to spatter on the wall. Ms. Henriquez also mistakenly stated in her statement that the incident occurred on 8th of March and could not recall why she put that date in the statement. She realized she had gotten the date wrong when she was recently reviewing texts between her and Nathan Holmes about McDonald's. She had no knowledge of any disclosure of photos with Mr. McLaughlin. To that, I would respond, the fact that both Whitney and Heard changed the date of this incident on the exact same day on the stand, in my opinion, really points to collusion and falsifying evidence, as it's too much of a coincidence. Like, they both changed the date in their statements to the same date on the same day. It's too much. This occurred the day after Depp's counsel completely discredited this allegation. Next, defense says, the claimant's use of cocaine on that occasion is corroborated by the photo at blah, 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 of lines of white powder taken on 22nd March of 1:37 p.m. The claimant accepted that the powder was cocaine. An imaginative but ludicrous theory was put in cross-examination to Miss Henriquez, though not to Miss Heard, that the image seen on the photo was a setup. Miss Henriquez denied this and explained that she had used a tampon applicator in the photo to take cocaine, and also showed the claimant this method of taking the drug. Miss Henriquez also confirmed, with reference to texts sent from Miss Heard to her at 3:08 p.m., that same afternoon, less than 2 hours after the photo was taken, that she was not present when the photo was taken. To that, I would respond that it's ridiculous that defense counsel even refers to this photo, as Whitney has now confirmed the cocaine in the photo and the applicator belonged to her and not Johnny. Even though I'm not sure how this staged photo would prove he is an abuser, even if the cocaine in the photo was his. Next, defense counsel says, Ms. Heard's account is at paragraphs 94 to 96 of her statement. In oral evidence, the claimant denied using drugs or being violent towards Ms. Heard. He accepted that he had referred to himself as the monster, but said he had done so in order to placate Ms. Heard. Ms. Heard said in oral evidence that this argument resulted in Johnny kneeling on my back and hitting me on the back of the head. She recalled that she attended a film premiere 2 days after the assault and recalled being concerned about any visible bruising on my back because my back was exposed. Ms. Heard stated that she did not have any visible injury on her back, saying, I remember checking obsessively as soon as I got off the red carpet. To that, I would respond, if this incident had happened and Johnny had put his entire weight on Amber's back, there's no way she would not experience back pain or bruising. She would most likely find it difficult to walk in heels or to walk at all, and she would certainly not dare wear a backless dress in this instance. Next, defense says, Ms. Heard saw very considerable damage to the property when she got up on day 3. Ms. Heard explained that she had herself caused very little of the damage. She only broke one thing, a bottle, and did not do any of the graffiti. To that, I would respond that yet again, the story changes. She originally described a 3-day hostage situation where Johnny beat her mercilessly for 3 days straight. Now, in this version, she awakens to find the place trashed and states Johnny had injured himself. While on the stand, she denied being the reason for Johnny's finger being severed and changed her testimony several times on the stand as to whether or not she had seen the injury take place. Her most recent retelling stated that he had severed the finger from punching her and the wall. Next, defense counsel says, further evidence of the claimant's mental state is provided by the fact he delayed so long before leaving the house for hospital, despite having a serious injury. He texted Dr. Kipper at around 11 or 11:30, but according to Dr. Kipper's notes, was still having a hard time leaving the house at 1300 hours. The claimant explained the delay by saying that he went to sleep, again suggesting he was in a highly disturbed state of mind. To that I would respond that the defense counsel forgets that Johnny experienced an extremely severe injury that required emergency surgery to reattach his fingertip. He would have lost a lot of blood and been in a state of shock, so it stands to reason that, yes, he would not be in his right state of mind. Next, defense says, Ms. Heard did not witness the claimant sever his finger, but believed he caused the injury while smashing a phone. The defendant's case on the claimant's fingertip injury, that the claimant caused it himself, is corroborated by contemporaneous texts as set out in Appendix 2. Notably, the claimant's text to Dr. Kipper just after the incident on 7th March 2015 states, I am so very sad. I cut the top of my finger off. What should I do except, of course, go to the hospital? I'm so embarrassed for jumping into anything with her. This admission that the claimant had cut his own finger off came in a text to which he was referring to Miss Heard in insulting and demeaning language, so had no reason not to accuse her of cutting the finger off if that had not been true. To that, I would respond, Johnny did not tell anybody because he wanted to protect Amber. In the recording, she clearly says, I didn't mean to do it, and Johnny thinks it's my fault, which corroborates Johnny's finger that his story that his finger was severed due to Amber throwing a vodka bottle at it, with the bottle shattering the bone upon impact. Not to mention the other people present also insinuated in the audio that it was her fault. And if you break it down, he says, I cut the tip of my finger off as a figure of speech, as it is his finger that got cut off clearly. Then he references Amber saying, I'm so embarrassed for jumping into anything with her. Why make that connection immediately afterwards and bring up Amber if he had cut his fingertip off himself? Next, defense counsel says, it was put to Miss Heard that she cannot have experienced a hostage situation since she was able to leave the property. Miss Heard agreed, but explained what she meant by the phrase hostage situation. It was not meant literally. Instead, it was a description of her feelings about how she had felt. This was my marriage. I lived in it. To that, I would respond that this statement is an attempt to explain away the fact that Depp's team brought to the court's attention that Amber had her phone and was able to leave at any time, despite going into detail of how she was kept hostage and abused for 3 days straight. That was not a figure of speech by any stretch of the imagination. Now, defense counsel has chosen the narrative that she was sleeping at the time that Depp injured himself, when she had said that she was awake and on day 3 of her constant abuse. Amber Heard was caught in a lie, and they refused to accept logic or facts and take her word as gospel, despite a strong lack of credibility. Next, defense says, in oral evidence, Miss Heard confirmed that the claimant had hit her with the hand in a cast while grabbing her with his other hand, and had also hit Miss Henriquez with the cast. Miss Heard had mentioned that the claimant's hand was in the cast in her declaration filed in the U.S. libel proceedings. To that, I would respond. Mr. Depp's finger was in a cast due to a severed finger. How could he have possibly been able to grip her hair with one hand and punch her with the other when he had use of only one hand? The cast he was using was a soft cast. Had he been using a hard cast, maybe this would have been plausible. But he would not have been able to use his cast to hit anybody without causing injury to himself. Next, defense counsel says, when asked how she applied makeup to Miss Heard, she said, referring to Melanie Iglesias, she said, well, obviously concealer. I tried to conceal some of the bruises, foundation, a full face of makeup. And one thing I do remember very clearly is although Amber's signature lip is a red lip, so it is not uncommon for her to have a red lip, I remember having a discussion that day that we had no other choice but to do a red lip, a bright red lip. She said that she was able to conceal the bruises with concealer, so they were not evident. To that, I would respond that Bruises swell, and by her own admission, Miss Ingleses stated that there was no swelling. There is no way injuries that would have been due to abuse, perhaps more likely to be Botox or filler bruising if it was that easy to conceal. If Amber's lip was split, how would she have been able to stretch out her lips without pain and make that crinkled face that she made in those photos? It would not even have crossed her mind to make this face if her lip was split and she had 2 black eyes and a messed up nose. Next, defense counsel says, much was made by the claimant's legal team of Mr. Jenkins' evidence that he saw Miss Heard vomit in a car park. However, the basis on which he identified her was her clothing. He did not see her face. In fact, it was Whitney Heard who vomited. A photo from Coachella showed them wearing very similar outfits. Miss Pennington remembered Miss Heard vomiting privately, but that was not in the car park. Little significance can be attached to this vomit issue, since it is not in dispute that Miss Heard had taken MDMA and mushrooms. To that, I would respond that Miss Heard had told the nurse that she became sick, as noted in Amber's medical records. When Amber was confronted with this on the witness stand, she denied getting sick at all, stating that she only felt like getting sick and denied puking at any point during the trip. Therefore, whether Amber got sick in the car park or in private doesn't matter. Either situation proves she lied in her testimony and that she is not a credible witness. Next, defense counsel said, the injuries were less apparent on the 28th of May photos taken when Miss Heard visited her lawyer, but she explained she was wearing makeup on that occasion, as she almost always did when she left the Eastern Columbia building. As Miss Ingleses explained, it was possible to cover up injuries with foundation. To that I would respond, what would be the purpose for Amber to show her bruise at court where it was not necessary for her to attend at the first place? There were text messages between her and Io confirming she either called the media or knew they would be attending the hearing. What would be the purpose for her to then cover up the bruise the following day and apply no other makeup? It is my opinion that she was not wearing makeup the following day when she went to meet her lawyers, and that the bruise was never there to begin with. Next, defense counsel says, Miss Cadenet texted Miss Heard on 22nd May 2016, the day of Miss Cadenet's birthday party, stating, sleeping sounds like the best thing right now. Put some arnica on your face. Make sure you have photos of the injuries, please, and text them to me or Rocky so there is a record. Sweetheart, I have been where you are, and it's excruciatingly painful, but pain is the cornerstone of growth, and you have an incredible opportunity right now to change your life. It is difficult to imagine why Miss Cadenet would have said this if Miss Heard was uninjured, and this demonstrates that Miss Heard told Miss Cadenet about how the claimant had been violent towards her. To which I would respond, Miss Cadenet was simply going by what Amber told her. It is interesting that defense counsel rely on this text message from her, as she renounced her support of Amber publicly. She stated that after the audio went public, she was shocked and appalled to hear Amber verbally abuse Johnny and neglected to testify on Amber's behalf. And finally, defense said it was suggested in cross-examination that Miss Heard had leaked her application for a DVRO to the press. She denied this and explained that the application was heard in a courthouse where our press organization, TMZ, has an office. Moreover, the claimant was on notice of the DVRO application, and his divorce lawyer, Laura Wasser, worked closely with TMZ, as Miss Heard explained. Miss Heard said her publicist, Jody Gottlieb, had told the police officer's business card, which ended up in the press, and may have shared it with the press. Miss Heard explained that Miss Gottlieb had asked her for it after a TMZ article had been published, which falsely stated that no police officers had attended the apartment. To that I would respond that this is clearly not true, as text messages between Amber and Io confirm. Amber advised that TMZ would be attending at court on Monday, after she had filed on Friday at close of day for divorce. Amber absolutely knew in advance that the media would be in attendance, nor was she required to attend, but she wanted the media circus that would ensue in order to generate publicity for a career. At least that's my opinion. Okay, guys, so that was the last point that I had. So, yeah, that was a long and wild ride. If you are still here, thank you so much. You are a real one. There was a lot to go through. I didn't, of course, go through every single point, but I just thought, the most important ones. So again, I have nothing to do with this case. This is just my opinion as a professional. I encourage you to come to your own conclusions, research this for yourself. But yeah, this is what I think. And if you agree with me, let me know. If you disagree with me, let me know. But let's talk in a mature manner. But yes, thank you so much for watching, and thank you for all the support throughout all the series. It's been a lot of fun getting to know so many of you, and I'm still gonna do a video on Johnny's side's closing statements. But yes, thank you so much for watching, and thank you so much for being here. I appreciate you all so much, and we'll see you on the next one. Take care. Bye.